right. Make sure that the okay. So this is the Charleston County Circuit Courts. The Fields presiding. Notes for the jury. So this is a wrongful death tort case, okay, alleging negligence on the part of some homeowners. The parties have stipulated, which means they agreed to a certain set of facts. And I'm going to read those facts to you in just 1 second. But first, let me give you the definition of negligence. Okay, so this is the operative definition of negligence. Negligence is the doing of some act which a reasonably prudent person would not do, or the failure to do something which a reasonably prudent person would do when prompted by considerations which ordinarily regulate the conduct of human affairs. It is, in other words, the failure to use ordinary care under the circumstances in the management of one's person or one's property. Okay, so that's the definition of negligence. Here are the facts of the case. Okay, so I'm just going to read them. So Donald and Gloria Bowden, who are in this case the defendants, hosted a cookout at their home in South Carolina, inviting mostly business acquaintances. Justin Parks, who was 19 years old, came to the party with his friend Mason, who was one of the Bowden's business's acquaintances. Alcoholic beverages were available to all of the guests, even those who, like Parks, were between the ages of 18 and 21. Parks consumed alcohol at the party and left with Mason. Mason drove Parks to Mason's home to give Parks time to sober up. Parks then drove himself from Mason's home and was killed in a one-car accident. At the time of death, they had a blood alcohol content of 0.291, which exceeded the state's limit for driving a motor vehicle. Linda Parks, Justin Parks' mother, filed a lawsuit in South Carolina State Court against the Bowdens, alleging that they were negligent. Those are the facts of the case that have been agreed upon. Here is a notes page that you guys can use to take notes, and I suggest that you do as a jury. On the facts that you see. So, and you also get a copy of the testimony after the testimony is given. So, with that all being said, let's proceed with this case. This is going to be the outline of how we're going to proceed today. So we're going to start with opening statements from the plaintiff and the defendants. And then we have a preliminary question, which is unusual, of the law to be applied in this situation. So let's start with the plaintiff team. Would you like to give your opening statement? Okay. Go ahead.
Your Honor, members of the jury, McCabbage, Whitmire, Lind, and Ruff represent Linda Parks, the mother of the deceased, Justin Parks. We are here today because of a tragic and avoidable incident that occurred on the night of September 22nd. On that evening, Donald and Gloria Bowden hosted a cookout at their home, inviting family and business acquaintances, including Justin Parks, a 19-year-old minor. As also present at this event were other underage individuals. Alcohol was made freely available and accessible to everyone in attendance without any effort to verify the ages of those consuming it. Justin Parks consumed an alarming quantity of alcohol at this cookout. At the time of his death, his blood alcohol content was at a staggering 0.291%, well above the legal limit of 0.08% for adult drivers. He was in no condition to make sound decisions, let alone safely operate a vehicle. Early Sunday morning around 2 a.m., Justin tragically lost his life in a single car accident. This case is not about negligence. This case is about negligence. The Bowdens, as the host of this event, provided a setting where minors could easily access alcohol and consume it in excessive quantities. We will demonstrate that their reckless failure to prevent underage drinking directly resulted in Justin's death. Since the cookout took place on their property and made no effort to prevent minors from drinking, the Bowdens must be held accountable for breaching their duty of care.
Okay, very well said. All right. So for the defense, do we have an opening statement from you?
Yes, Your Honor, we are the firms Shepherd, Smith, Moats, and Cruz, and we are representing their client, the Bowden family. This case involves a tragic accident and a claim of negligence against the Donald and Gloria Bowden. While it's undeniable that Justin Park's death was a heartbreaking event, the evidence will show that Bowden family was not responsible for his actions. They hosted a social gathering where alcohol was available. They had no control over the individual choices made by their guests, including Park's decision to drink and drive. The Bowdens didn't directly serve alcohol, nor did they contribute to the Park's decision-making process. Instead, the focus of negligence should be shifted towards the choices made by the individuals directly involved, rather than holding the host liable for actions beyond their control. Thank you.
So, an unusual thing, so in most jury trials that we have, the law is relatively set, right? In this case, we have a novel question of law. This was actually the case in the Orgenberger case that we covered in class, although it doesn't really read that way when you read it. I've lost my remote somehow. So what we have today, we have to understand something about the law in South Carolina. And I've prepared this handy little chart. Well, let's talk about negligence generally. Okay, yes, what do you have?
Get short on papers.
Sorry about that.
Right here.
Anybody else need a paper? So, yes. And you guys, for you should be taking notes because you're okay. So this is the so we need to understand the law as it exists right now in South Carolina for both civil and criminal liability. You guys remember that criminal liability is when you're charged with an actual crime, whereas civil liability is when you're charged for money damages. Like if you injured yourself at Walmart, you would sue for money damages. You wouldn't sue Walmart. Walmart wouldn't go to prison, right? It's a suit for money damages. This is a suit for money damages, alleging negligence. So this is this current state of the law as it exists in South Carolina. Okay? So if you guys want to take just a brief look at this. In general, the law in South Carolina, we're dealing with an unknown area of the law. The law differentiates between adults and minors. Okay? It treats them differently. So, for instance, if you serve alcohol to an adult, in general, the only way you are held liable for what happens as an adult is if you're in a business and you are serving a clearly intoxicated person. It's illegal to do that, and it's also potentially civilly liable. Okay? Whereas for minors, you can have criminal liability for knowingly selling alcohol to minors. Minors come into your shop and you sell alcohol to them. That's a felony, but it's a misdemeanor or a lesser charge if you provide alcohol to minors in certain public settings. So if you give your buddy a beer at the game who's only 18, you could get potentially charged with a misdemeanor. Okay? Civil liability for minors also exists where businesses sell alcohol to minors and they take it out in the parking lot, they drink a few beers, they drive drunk, and they hit somebody. That person has been allowed to sue the business for selling to minors. Okay. Now, if you sold that same beer to an adult, there would be no liability for the business at all, right? As a alcohol retailer, as a convenience store, for instance. On the next, so that's when you're intentionally giving or providing or selling alcohol. When you're negligently providing it, like you don't take due care, in general for adults, there's no liability at all. If you go to a party with an adult then there's a case that said, even though you went to a party and even though you got drunk and you went out and injured somebody else, it's not the fault of the person that hosted the party when we're dealing with adults, because adults are supposed to take care of themselves. However, we're dealing here with negligently providing alcohol to children. Or to minors. That's what's being alleged here. There's no criminal liability in the state of South Carolina for this act. Okay. However, we're talking about civil liability, and that's what this case is about. So, with that all being said, where's the duties? We want to talk about what standard of care should apply to this case. Remember that in negligence action, we have a duty that's breached that causes harm. So the question is, first and foremost, what is the duty? So let's start with the plaintiff party. What duty should apply to and you can argue more than one, so you don't have to argue just one. But what duty of care should be provided in the Bowdens that wasn't in your estimation?
The Bowden should obviously keep everyone safe who's on their property and not be negligent and leave alcohol out as to where minors are at and have them freely get it whenever they want.
So you look at the standards of care. So talking about the duty of landowners, of business invitees, retailers, like where does the social host liability, where would you describe that standard of care to be? Go ahead. Anyone can jump in.
It's the social host liability.
So social host liability. Okay. So under the social host liability, what is it that you feel like that the Bowdens didn't do that violated their standard of care?
Obviously, they didn't keep the alcohol out of reach for minors, so I feel like it's their duty to be responsible to not let them drink on their property. Just keep it out of the view, really, and it can hurt others if they get, confiscated on them.
Okay, so your argument is that even though there's no social host statute in South Carolina, that's the standard of care that should apply.
Yeah.
It's some sort of proactive steps to avoid serving or negligently allowing minors to have alcohol. Okay, all right. So, did anybody have anything else they wanted to add to that?
Yeah, knowing that there was gonna be families there, there's also gonna be kids there, they should add on to that. There should be signs stating that there is alcohol there and where the alcohol is at, and there should be, they should.
So sort of a duty to warn or to make known that there's alcohol here and it's readily available to anybody that wants to partake in it. Okay, those are good points. So that would be more in the kind of a business invitees of risk, like warning proactively of care. Okay, that's yes, but that element may apply to homeowners as well in this case, because they're hosting a party where minors are involved. What standard of care do you think should apply? Defense?
Well, I feel like there's a lack of responsibility in this case because there are no strict statutes about the responsibility of the host.
So that's a very good point. Let me stop just for a second. So your initial point is that there's no criminal liability. Like the Bowdens are not charged with any crime, right? No police officers have shown up. Nobody's pressing charge. Nobody's been able to press legal criminal charges against the Bowdens, right? So that's your starting point. There's no criminal liability. Okay. So which standard, now they have some standard of care, but what should that standard of care be here?
Well, I think it should be on the people coming. I mean, if they're obviously driving to the party, they have to have some form of rational thinking. And if they're under the age, they should obviously not drink alcohol, even if it's provided at the party.
Okay. So your argument is that the standard of care should allow the homeowners kind of the greatest breadth of freedom, so to speak. So
I would say that the duty of the landowners is basic because they provided the social setting. And the rest is left up
So they provided the social setting and nobody was injured
on their property.
on their property, right? Which is the basic duty of landowners, right? To keep people safe while they're on your property. Okay, right. Let's have, before we go any further. What do we do? What I want to do now is I want you guys to give, I want to give your statement of the case for the plaintiff. So plaintiff, what we're doing now is I want you to walk your way through the elements of proving that there was a negligent action in this case, and also doing the testimony of Mason Justice. So why don't you guys start with your statement of the case? Why should the Bowdens recover? Or why should the Parks recover for the death of Justin? Why should it be the responsibility of the Bowdens? Go ahead and give your statement of the case. You just say what we're gonna work your way through the elements. Duty breach causes harm and the defenses. So if you've got that information, so go ahead.
So we think the Bowden should be held accountable because there was alcohol present and they knew minors were there and took no extra precaution to let the minors and or the parents know that there was alcohol present. And they also had a caterer serving food, and they also stated that there was an open bar situation and they could go up and grab whatever they wanted whenever they wanted. And then we also looked up the definition of harm for the duty of landowners, and harm can be physical, emotional, and mental or financial. Yep. Which leads us to the fact that drinking alcohol on your property, on anyone's property, can inhibit your thinking and, you know, your actions and stuff. So we also said alcohol has the effect of making a person incomprehensive and impacting their psychological thinking and processing abilities, which comes to the conclusion of potentially not being coherent enough to make the right decision.
Okay, so just kind of recapping that a little bit. So the Bowdens had a responsibility and a duty to do something, correct? And so work your way through, so they had a duty to do this, but they didn't do that, they breached the duty. How did that cause the harm? And the cause has to be two ways, okay? The cause has to be but for these actions. Right, so this is what I want you to address every single one of these points, right? Was there a duty, you know, and how does that actually translate to real world? Was it breached? And did that breach cause, in both ways, the harm that befell Justin? Because he's dead, so we have a harm. We have a dead teenager. So we already have, so there's no disputing that there's a dead teenager. So it's really, those are the three elements. So go walk your way through that and prove your case.
So the duty of Gloria and Donald were to keep everyone safe at their house, especially the minors, with an open bar type situation present, so that the minors wouldn't drink, or at least Gloria and Donald also could have ID'd everyone there if they didn't know didn't know the ages of the kids, because it also stated they assumed they were old enough, which is never good enough. They breached this because, I mean, obviously one kid had way too much to drink, and we found out it was Jaeger. And he was driven to someone else's house.
Okay, so you're getting testimonies, but so did they breach their duty, and how did their breach cause the harm? So let's just do, so let's get to that causation element, because that's actually kind of key. How did the Bowden's actions cause Justin to be dead?
They were negligent.
Okay, so they were negligent. So it's these two tests that we're looking for. So but for which actions of the Bowdens would have started the dominoes that led to his death? Corey, do you want to?
So they shouldn't have provided alcohol in the first place, and they didn't do their due diligence when they saw him drunk leaving the party and they acknowledged seeing him leave, that led to what happened later.
So the alcohol in his system, so but for them, if he didn't have any alcohol in the system,
That's number one. And then
That's
number
the but for.
two is they noticed him drunk and they didn't do anything to stop it or protect him.
how is the alcohol in his system foreseeable that would lead to the type of injury that occurred in this case?
He had a .291 alcohol level at the time of death.
He was visibly stumbling.
So it's foreseeable that somebody who has that much alcohol might not make, you said they might not make good decisions,
Yes.
including the decision to drive or not drive.
Right.
And that led to him making a decision to drive. And he drove and killed himself. Okay.
No protective measures were taken after that point.
Okay, so I think we should stop right here and have the testimony of, if Logan can come up. So one of you needs to be the questioner. Logan is gonna be is stepping in as the role of, this is Mason Justice. Mason Justice is the friend of Justin. So
I don't have to ask every question, I'm gonna ask certain questions.
now you need to ask everyone,
Really?
really, all of them. This is the most critical evidence. This is the biggest part of evidence for this case. So as a jury, please pay attention. Go ahead. Try to be loud. Yep.
Do you promise to tell the truth, the whole truth, and nothing but the truth, as God is your witness and Jesus is your Lord and Savior?
I don't say that in actual court. That's not true. So go ahead.
What is your full name for the record?
Mason Justice.
Did you know Justin Parks, the deceased?
I was a good friend of Justin before he died. We went to school together and we were friends in second grade,
For the record, how old are you?
20 years old.
Did you attend a party on the night of the 22nd of September at the Bowden's house?
Yes,
How did you get to the party?
I drove my car and Justin came with me.
How do you know the Bowdens?
My dad used to work with Mr. Bowden at his company and I had met them before at one of my high school lacrosse games, but I had never been to their house. The party was a lot of people from Mr. Bowden's business, but it seemed like there were other people there too, like the other lacrosse parents. The Gamecocks had a bye week, so I went to the party.
Were you invited to the party?
Well, my parents were. The invitation was for our family, I guess. My parents told me about it, but that was because I know the Bowden son, Brandon. He was behind me in school by a year and we played lacrosse together.
Did they know you were at the party?
Yes, they saw me when I came in.
Would the Bowdens recognize you if they saw you?
Yes, because of their son, Brandon.
Would they know how old you are?
Probably. Brandon's only 1 year behind me and he just turned 19.
While you were at the party, did the Bowdens serve you alcohol?
I wouldn't say it that way. We got it from Brandon mostly. I did go up and get a beer once, but no one served it to me or said anything to me. I just grabbed it.
Did the Bowdens see you drinking alcohol?
We were in the basement playing Xbox and watching football. They were all outside. I guess I'm not sure. Brandon says they were cool with him drinking at home as long as he stays there. They were pretty busy with the rest of the party and I didn't see them at all downstairs.
Were there other young adults there between the ages of 18 and 21?
Yes, a couple of other guys from the lacrosse team, same class as Brandon, but they were all trying to hit on Brandon's sister or something. That really pissed Brandon off.
Were they with their parents?
I saw the parents of one of the guys
Where was the alcohol at the party?
at the bar by the pool.
Was anyone in charge of the bar?
Not that I saw. They did have some caterers that were serving food in their 3-season room, but the bar was kind of off to the side and open. When I got my beer, no one was there.
Was Justin drinking at the party?
He was in the basement drinking a lot. He was losing at Xbox and depressed his team was losing the football game, so he was kind of pounding Jägermeister.
Did he get drunk at the party?
Yeah, he was pretty drunk. That stuff is way more powerful than you think, and he was drinking it like it was Gatorade.
Were you drinking?
I had a couple of beers early in the evening, but I capped off by 9 or 9:30. I had to drive,
When did you leave the party?
about 11 p.m. The party had pretty much broken up by then.
Did the Bowdens see you go?
I saw Mr. Bowden when I got in my car. He was out saying goodbye to some people. I yelled goodbye and thank you.
Did the Bowdens see Justin when he was drunk?
Maybe. Brandon and I had to walk Justin out to the car, because he couldn't walk straight. I was worried he was gonna puke in my car and it would smell like puking Jaeger. But, or plus Brandon was laughing at Justin whenever he would stumble, so it was hard to miss it.
Did the Bowden say anything to you when you left?
No, Mr. Bowden sort of half waved to me, but he was busy talking to other people.
Did anyone else see Justin drunk at the party?
Brandon did for sure. Justin was kind of obnoxious and went upstairs to piss a few times. He told me he ran into Mr. James, one of the partners that works with Mr. Bowden, and spilled Mr. James' drink all over his shirt. So probably a few people saw him and clearly had been drinking.
Did Justin ever get served alcohol by the Bowdens?
Not that I saw. Like I said, they weren't serving people. It was kind of just self-service. I'm not sure if Justin got a bottle of Jaeger from the bar or if Brandon got it for him.
Did they know where you were taking Justin?
Well, no. Brandon joked with me about Justin puking in my car when he helped put Justin in my passenger seat, but I didn't tell him where I was going.
Where did you go when you left the party?
I drove back to my house. Justin's car was there from when he came over to watch football before the party.
What did you do with Justin when you got home?
Well, he was still kind of out of it, so I dragged him inside and got him to lay down on the couch in the basement. He kind of passed out, so I just left him there to sleep it off. That's why I didn't get his keys. He was out, and I didn't think he would wake up until noon on Sunday.
What happened next?
Well, I woke up at like 6 a.m. because I had to take a piss, and when I came out, Justin was gone. I didn't know what happened to him until Sunday night when his mom called crying, telling me that Justin was in an accident at 2 a.m, wrapped his car around a tree from a mile from my house.
Is it possible that Justin had some alcohol at your house?
No, my mom used to be an alcoholic, so we don't ever have alcohol in the house.
No further questions, Your Honor.
Thanks. Okay. So now we have some additional information, okay? Is there anything else you'd like to add to the basic statement of your case? That there's a duty that was breached that caused harm before we get into some of the other aspects of the case, based on the testimony that we just heard. No. So we will flip it over to the defense then. So the defense, can you give a statement of the case to, now we have the basic duties up here, but we also have several defenses that we need to talk about as well. So before we get to the defenses, is there anything you want to respond to in terms of the statement of the case, or make a proactive statement about this duty breach causes harm rubric that we're looking at right now?
Well, taking our stance like as saying that our only responsibility as the landowners is to just provide the setting. The actions that occurred independently after Parks left the Bowden's house, they do not involve our party.
Okay.
Because we have no responsibility.
All right. So why don't we get into those? These are the defenses that normally can apply to a negligence case. The three defenses that are generally viewed under the law are assumption of risk, that the party knew and understand the risk that they were taking on, similar to the baseball case that we covered in class. Okay, that's assumption of risk. The second being superseding cause, meaning something happens to relieve the original party of liability, an intervening factor that means that they shouldn't be held responsible, that breaks the chain of causation, like from the act that they did until the ultimate injury. Okay. And the third being contributory negligence, which generally deals with damages, which is that each party is somewhat responsible for it. So you have to allocate responsibility. So it's not all on the homeowners. Which of these would you like to argue, or you can argue all of them?
Superseding cause.
Okay. You don't have to choose just one. Why don't you just work your way through them? Okay. So assumption of risk. What would the argument be for the assumption of risk when it comes to Justin? What do you guys think?
He was the one that willingly, like, willingly went up to.
So do you think that Justin knew about the risk potentially of drinking? Why would he know about the risk of drinking? He's 19 years old. What do you think? I mean, you guys have experience.
His mother has history. Or his friends.
Yeah, so it's not well, his friend's mother, yeah. So yeah. So that's one potential danger. How would he voluntarily assume the risk of his actions?
He wasn't just drinking like a beer here and there, he was drinking like alcohol with him.
Yeah, he was drinking hard alcohol and a lot of it. Okay, so that says that we don't know his level of familiarity with alcohol. We don't know how much he's had it in the past, but in this case, he was drinking a lot. So okay. Superseding cause. What's the argument for superseding cause? That there was some other factor that should relieve the Bowdens of liability that happened in this case.
Well, Mason Justice drove Justin Parks home and attempted to get him to lie down and rest for a while, but then there were a few other areas in the chain of events that caused him to drive home and wrap his car around that the Bowdens had no control over. Because one, they hadn't seen him all night. I mean, they might have seen him here and there, but he was in the basement the whole night, so.
Okay.
They had no idea that he was leaving. Only their son knew directly that he was leaving and going to Mason Justice.
And the son is not the homeowner, right?
Yes.
So, right,
Exactly.
so, okay, okay. And, so the superseding cause in this case, you're arguing that the friend is the superseding cause?
Yes.
Okay, okay. All right. And how does the friend break the causal connection between the alcohol that was negligently provided, that he drank, right? That they were unaware that he drank, and his ultimate death? How does it break the causal connection between those two things?
He saw him from beginning to end. He saw how much he was drinking. He took him home and he didn't see it through. He didn't make sure to watch him while he was sleeping. He knew how much alcohol he actually did, and he just went to bed and left it.
Okay, okay. All right. Contributory negligence, that the person that was injured was contributorily negligent towards his own death. What do you think?
He knew how much alcohol he was drinking, but depending on how much experience he has with drinking alcohol.
Yeah. Yes, but what if he had a lot of experience? Would that make him more contributorily negligent towards his ultimate death? Why is that?
Because he knows what the outcome is and he knows the danger of it.
Okay, those are good. Okay, those are good arguments. Okay, so we've now given the statement of each case. I'm going to do some judge questions. This is where I question counsel on each side. And so just some basic questions. So for the plaintiff, why shouldn't the intervention of Mason relieve the bounds of, like, wasn't Mason taking over responsibility for Justin?
Mason was underage and also had alcohol at the party, so he was in the wrong in that situation. And then being impaired, having drinks, he shouldn't have been responsible because he wasn't in the right conscience to take care of somebody else.
So you're trusting a minor who's drank to take care of another minor who drank. So you mean like it's like just error upon error upon error. Okay. So why doesn't it break the causal connection? Like what is it about? Why should we as a court treat this situation differently? I mean, he's 19 years old. I mean, 19 years old is not fully an adult, but does he really not understand what he's doing? What do you think?
I think he does understand what he's doing. Are you talking about Mason?
No, I'm not talking about, I'm talking about Justin.
I think he knows what he's doing. I mean, Brandon, the son of the Bowdens, stated that his parents let him drink if he stays at home. So I can just assume that Justin's been over there before when Brandon was drinking. So maybe it was kind of.
Yeah,
no
that's,
one-
I mean, that's outside of our facts. We don't know that for sure. So but in terms of like making your case, like, why should we view Justin as a minor and not an adult? He's 19 years old, right? He's not 15, he's 19. Why should we consider his status to be something different than we would treat an adult?
Well, he's a minor in the sense of drinking, so drinking is 21 and under, and that's considered minor. Not like minor and adults, like 17 and up. So in this case, he is minor with the drinking aspect.
By law.
By law, yes.
So the law treats minors differently. So whatever the reason is for that bright line, there's a reason why that bright line exists. Okay. Okay. So was Justin capable of assuming the risk that he took on as a minor? What do you think?
Yes, but he didn't, no one told him when the cutoff was. I don't think any of his friends were,
Why do we have those laws? Why do we have a law why do we differentiate between maturity, right? So if he's under that age, then the assumption is he's under age 21, and the reason for the law is because when you get to that age, you're supposed to have this maturity. Then we can assume that the law is there to protect his immaturity from his own immature decisions. Okay, all right. So then, is he capable really of assuming the risk if he doesn't understand the implications of his decisions?
he may, I mean, he did, I mean, if he's not around it, like if his parents aren't around it and he's not really around it, then how does he really know the true factors of it? We don't know that information, so.
Right, okay. Okay, so, and in terms of contributory negligence, okay, did you want to make any statements about contributory negligence at all? No.
So like damages.
Yeah, so it's just like, yeah. So like, why should we look at this situation and say the most responsible party here is the Bowdens, the ones in the best position to prevent this harm, and therefore they should have the most cost, should be the Bowdens. Why should we look at it that way?
Well, seeing that Mason also had a couple drinks to start with, and he capped off by around 9:30. There's an expert testimony behind it here, but it takes around 69 minutes for alcohol to reach the peak levels of blood after drinking. So, and they leave around 11. So that's about like the highest point of the alcohol levels. So it could also like mess with Mason's cognitive thinking and reasoning while he's driving back home and sitting on the couch and all that, even though it's good intention.
So it impairs his decision. So the minor who's taking care of the guy is also making impaired decisions. He's not making the best decisions, right? So like he didn't take his keys away, right? There's an example of a decision that he didn't make, right? So okay. So when you look at the totality of the circumstances here, would you say that it's like the biggest part of the problem would be the Bowdens because that's why? Why is it they're the biggest part of the problem?
Because they provided the alcohol and there is no supervision for minors.
And so once the alcohol gets into a system, then all the effects that are foreseeable of alcohol come into play.
Yes.
Okay, that's a very good argument. Okay, so to the other side, okay. Why shouldn't the Bowdens be completely responsible for the actions of this?
They never directly served them out. Because if they had, then in that case, they might have been like, no, you're not 21, then you can't have it. But their son is the issue and the determining factor in this case because he allowed them to have the alcohol without his parents knowing that they had consumed it. Because there is no direct, like, there was a bar, but nobody ever served it to.
So nobody ever,
Should do.
so here's a beer, here's a little Jaeger to have.
Yeah.
Drink this up, have a good time. Nobody ever did that. There was no direct survey. Okay, okay, okay. All right, closing statements for each side. Just make a brief closing statement about why should your side win? Why should your side win? Plaintiffs go.
Bowden had a clear duty to ensure that minors at their home did not have access to alcohol. They breached that duty by allowing alcohol to be consumed freely without supervision. This negligence directly caused the intoxicated state that led to Justin's tragic death. We ask that you hold Donald and Gloria Bowden accountable for their actions, for the breach of their duty as a social host, and for their irreplaceable harm caused to Justin Parks and his family. The law is clear: when adults fail to protect minors from the dangers of alcohol, they must face the consequences.
Okay, all right. Statement for the defense.
Based on the chain of events, the Parks consuming alcohol and being driven to justice by justice, and then choosing to drive himself, showing an intervening cause in the chain of responsibility. The Bowden's role as the host does not extend to the control of the outcome in it. Justin's own actions after leaving the party at the Bowden's were completely independent. Other chain of events occurred leading to Parks' accident that don't directly relate to the Bowden. Thank you.
Okay. So now I'm going to turn this over to the jury. Okay, so we're going to organize the jury into 3 different jury pools. Which yeah, sort of. You see this? Two, four, 6, 8. So we 2 juries of 4 and 1 jury. So I'm gonna count you guys wrong. So 1, low meter 2, 3, 1, 2, 3, 1, 2, 3, 1, 2, 3, 1. Okay. So when you're a jury, the burden is on the plaintiff in this civil action to prove every essential element of his claim by the preponderance of the evidence. That's the standard that we use. Preponderance of the evidence means that such evidence that, when considered and compared with that opposed to it, has convincing force and produces in your mind a belief that what was sought to be proved is more likely true than not true. Okay. If the proof should fail to establish any essential element of the plaintiff's claim by preponderance of evidence, then the plaintiff has failed to carry their burden of proof, and you must return a verdict for the defendant. If there are any defenses, likewise, that apply to relieve the defendant of their responsibility, then you must return a verdict for the defendant. Since this is a civil trial, you do not need a unanimous verdict. In Ohio, the jury must have a concurrence or agreement of at least 75% of the jury members. For our juries today, this will mean either 4 of 5 must agree, or 3 of 4 must agree, depending on if you have 4 or 5 people in your jury. Okay. For juries, it's not just a simple, yes or no, should they be liable? It's a series of questions that you must answer for each one. Okay. So the first side of this page, there are 4 different standards that could apply of law that we apply. And you must decide as a jury which one you're going to apply. Okay. And then so you have to decide, do we apply the duty of homeowners or business owners or as a social host? Once you decide which standard you want to apply, then you have to answer specific questions for that standard only. That's the duty part. And then on the back of the page, you have to go through causation. Does it cause the harm? And the 3 defenses that we talked about. assumption of risk, superseding cause, and contributory negligence. So I'm gonna break you into your juries now. I want jury 1 to be over in this corner, jury 2 to be just right here, okay? And then jury 3 can be over here, okay? So if you go to your juries, you'll have these questions. Deliberate amongst yourselves, answer the questions. Remember, 4 or 5 have to agree, or 3 or 4 have to agree. Put something down on the paper. And then when you're done deliberating, we'll announce the jury verdict. So where's one? There's one. And then 2 is over here someplace. So this way, you can gather over here. And 3 can gather over here. So make sure you fill that out. Wait, there's the break. Here's the time. Once you rest, then you work. Hey, yes,
You were thinking you're gonna put more.
Oh, did you really?
You were thinking like we were gonna say something, so like you're asking why they didn't like we say all this.
Oh, yeah, sorry.
So we were like really like.
There's like ethics involved.
Yeah, we know it's expensive. Yeah, we know.
This one in their practice, whatever.
So why is Mark do this?
No, it's good though, because like you actually, like you actually. Actually. Make these other videos.
Alright.
You guys feel like you're understanding the word.
Yeah.
What do you get? What is, I mean, it's tough to make it, it's hard to make it's like.
Yeah. Oh, yeah.
You know, it's kind of. That's why it's.
Trying to stay.
But at the same time, I think they would be.
They're just no adults or something.
You guys feel like you understand the
Yeah.
I would love that.
We reached out. So you guys will have a different situation right at the. I'll talk about it.
South Carolina, so we basically talk about
It's supposed to like.
Yeah, but when that's actually.
So in a brief, is what you serve, point in time. After trial, it's in my board. It's like.
it said.
It's no trial that's gonna take place for some. Why we should do it, why we should say that, why we should. Not like, it's like, there's no reason why one side is actually. It's like.
Yeah.
Each one.
It's pretty much like. It's all this stuff.
So like, so outside.
Pretty much trying to figure out who's.
And then you, what you'll do is you just fill it out, basically you'll fill out 3 sections of it. One for the first one.
So if you see now it's the includes.
And then you fill out these analysis questions, like, here's going through the elements to prove the case. And then conclusions is like, so it's like you're filling out 3 sections. So it's giving you a really firm track to run on, and then you do.
Who doesn't know? It's
I need stuff. So you guys. Give it a call. It's not like.
Yeah.
Before the trial takes place, say, here's why we should, right, so here's. Yeah, that's what you guys used to say, it's like, here's what I want the judge to do, you know, something like that. And then you're all inconsistent, and now. Going through this, trying to get these things done. And then also. And then.
They're not gonna follow. Yes, the Justin's car was at Macy's. Yeah. It's the sum of the.
I haven't seen this. But I just go out and you can just go out. So you'll this is a page of the mark. Each one, yeah, now it's the team.
What is that?
I'll tell.
Yeah, Brandon.
That's just fine.
Yes, it's this case. Just this case. Yeah, in the next case, you'll be. Twice. Probably. So once I got called right before.
But I think I'm on the jury date.
Was like next year. Friday night. And I was going through my mail, it's like. Yeah, sure. And I was,
No one knows.
So I go downtown. Get this big room and they're like, okay, we're gonna. You know, like living in the hotel, can't talk to the press, like all this stuff like that. Now it's lights, and it's within or later. Well.
Yes.
The defendant split out.
It's pretty much the same.
But it's also, yes. I mean, I don't think I would have actually, like, I would do this really cool, but like the way they do it is like, is each side, do you work? But the question is, and I would, you know, it's yeah, like, it used to be that you just said an attorney. Then they were like, why are we? Yeah, it's not. But, I think still more. Like one side, you get so many strikes. So it's like somebody want to be strikes. It's not. They ask questions like. Like they ask questions like try to figure out your orientation. Well, I'm gonna be like, wait, I'm not gonna get this. It's called
Like, there's a reason it's faulty. You know what you use.
That's great. It's hard to say. The first time I did this, like, I was like, And then give you any direction at all. This is one of my complicated ones. It's not good. This is actually, so look at the end of the chapter.
Like, the event would be. Or not, or staying. Basically, that's all.
Points, but that's the reason. I think that's what the problem is. Because this is so that it's time to get so get people to take this. But they're both. But he was like, he was like, he never said that. To me. Probably 2 days, told him.
There's no actual case.
I was.
So I guess this was actually nice. Actually, I thought it was. Next time. And that's the last one, just when you very fall. Did you really? Wow. Yes. Yeah, it was. Also important. So it's the.
I'll just write the fraction. That is. So pretty much. We were downstairs. I don't know if everything went like the beach.
We started. It's really dark tomorrow. It's just like it's all set. She's like, I have no idea. You're on. I mean. There are other places.
They do down base person, like. What we're seeing, like, stuff like they
I think the six is more of toss. I was saying, I feel like it's from, if it was a business.
So you guys can talk about it. So which of the so you're supposed to be one of these, which is.
You just see there's a, there's one, there's a, which you have to choose one. That you think should.
They were
Like
all.
choose one of them. But you answer all of them.
So we don't answer all of them?
Well, it's not what you did, it's like, the idea is like,
No.
is that we're choosing which law applies, which things.
So like we pick out the basis
You choose
that we,
one.
that we,
So what, which one do you guys feel like is the most like?
so
like the
Make sure.
So yeah, just starting with one. Are you guys done?
Yeah.
Which, yeah. You wanted to force in. Just choose which one you thought. Well, like. You choose one.
Yeah, that's what it accents.
But basically,
But-
Should they know, like this?
so, yeah, so. So which of these?
It's still used. Just
So like, which of those? is
Sure.
So, does that make sense? Yeah, they're almost done. You guys all set?
You circled this. I just circled those sometimes.
Okay, that's, so it's,
So do we still?
It's the word in drag, so we just.
well, it's kind of,
I know, but.
what's weird is that like, it's not, you don't come down. So most people, you're deciding, so. So, in other words, like, if you meet all those, meet all the criteria.
If people care, then those.
So if you said, yes, there was a duty, yes, there was school, yes, there was. And there was no defense of those spots. So it's still in a stage. So you, it's the chief, but you're inviting to all those. You are making the decision. Is it, did you say, well, did this relieve my life? Was there negligence? The staff? No, yes, but you could say there's superseding powers that should have been on the. So now. So you guys.
Up teams. That's what I want my right in the.
Results. So this is jury 1, 2, and 3. Okay, so we got duty breach causes harm, and we've got assumption of risk. We've got superseding causes. And we've got contributory liability, contributory negligence. Okay, so let's go through these. So I'm trying to, I've never quite done it like this before with the jury, all these jury questions, but basically, and it can be weird because like most juries just want to have like I think this party should win or this party should win, but that's not how we do it, right? You answer a series of questions, and then from those questions, you've determined whether they won or lost, right? So what was a duty for jury 1? Said what duty did you guys decide on was most applicable? Do you remember? Social. No, that's so you said social host. Jury 2 said social host. And jury 3 said social. So all of you decided that social host was the level of. Okay, and so then the 2 questions they asked under the social host was, did they knowingly provide alcohol to a minor? So we got the knowingly, and did they ruthlessly? Okay, so jury number 1 said, jury number 1 said no to each one of these questions, right? Jury number 2 said no to knowingly, but yes to recklessly. Jury number 3 said no to knowingly and yes to recklessly. Did they breach their duty? Yes, I mean, actually, these are together, right? So that's the first one. Did that breach cause? And then cause has 2 parts to it, right? So cause was, so the first one cause is, but for the failure to do something, did it cause the injuries, and was that injury foreseeable? Okay, so jury number 1 said yes, but for their actions. And then was it foreseeable? No. Jury number 2 said yes. Actually, that's not true. No, sorry. Jury number 2 said yes to both, right? Yes, but for their actions, and yes, it was foreseeable. And then jury number 3 said yes and no. Okay, was there harm? That's a yes, everybody. Okay, and then the three defenses. So the assumption of risk, did the plaintiff, did Justin know and understand the risk, and was he able to make the decisions? Jury number 3 said yes, he did to both of those questions. So yes and yes. Jury number 2 said yes and yes. And jury number 1 said yes and yes. Okay. Was there superseding causes? Jury number 1 said yes. Jury number 2 said yes. Jury number 3 said no. Yes, yes, and no. And then who's responsible? More responsible jury number one said the plaintiff was 25% responsible. Jury number two said the plaintiff was 70% responsible. And jury number three said the plaintiff was 7/12, so that's 62.5% responsible. You guys, getting down to the decimal point, loving that, 62.5, 62.4, 62.6. So if I'm looking at this entire matrix, then the answer is who wins this case? So this would be the defense wins this case. The this one is like this one's defense too, and this one's defense too. So defense sweeps it. You guys didn't even know. How many of you guys thought that the plaintiff won the case from your jury? Just a couple. So you think, and that's why they do this actually, right? Because if I think like there was no duty at all to begin with, they didn't knowingly or recklessly provide alcohol, then I may answer all the other questions and think that I'm saying like they're responsible, but the judge is gonna be like, no, I'm gonna throw out that jury decision because because you decide these facts. So, all right, what did you guys think of it? Just real quick before we go. First trial, not too bad, interesting.